Good evening. We'll be waiting for quite some time, but we can't keep waiting. We will make do with those who are here. For part-time students, you have another class tomorrow, God willing, at 6:30 with my TA, Mr. Ezekiel Osei, so that you continue with the discussion of duties of directors to the very end, because the regular students have actually exhausted that. So to ensure that you have a parity of treatment, I have decided that Mr. Ezekiel Osei should meet you and repeat for your benefit what he did with the regular students. So tonight we are continuing with a very special aspect of corporate governance, which we term as the majority rule and protection of minorities. Or if you look at the company law literature, you often find the topic, the rule in Harbottle, and exceptions dealt to. Or sometimes people will talk about oppression, a remedy against oppression, and so on, various will call. Well, but I think it suffices for us to just look at it from the point of view of protection of minorities and also what we call like the majority rule. I think that we are going to put it in a bigger context, and from that context, we will move on to look at provisions of the Act. I have told you that as far as I'm concerned, the most useful textbook on company law written by a Ghanaian author is one by my good friend and a mate, Mr. Ferdinand Adaje. Not because he's my mate or he's my friend, but based upon my critical and objective analysis. If it's not useful or it's not good, I'm not afraid to speak my mind, and I always do that. But if it is good, I have to be honest and acknowledge it and celebrate it. And so if you had his book, for example, I will recommend for you the chapter 23. That is from page 1064. That is what we need to supplement our discussion of the relevant provisions of Act 992, especially starting from section 218. But before we make progress with respect to our discussion of majority rule and protection of minorities, or what's in Act 992 is titled Protection Against Illegal or Oppressive Action, among others, I would like to bring to your attention a special tax which you have. And that tax is that I am directing, I'm not asking, I'm really directing, which means that it's an order that you should go read and study the provisions on company secretary and other officers of the company, specifically from excuse me, specifically from section 211, right? Section 211 up to section 217. Just about 7 provisions, because the rest we are discussing them with you, and the regulars have discussed all the rest already. And the part-times, you get your your share for the completion of the other aspects of the directors. And quite apart from that, I'm also directing you, and as I say, I'm not asking you, I'm directing, meaning that it's an order, to read and study receivers and managers. That is starting from section 261 right up to section 273. Yeah, so I'm directing you to read and study those provisions. They are very straightforward, and they are not technical for you to understand. And for that reason, we will not use our very limited and precious time that we have to finish teaching and learning, so that you can start your exams. We can use that. We can use that limited time for those straightforward topics. So just to reiterate, you are supposed to read and study the provisions on company secretary, starting from section 211 up to section 217, right? And also, you're also supposed to read and study provision on receivers and managers, starting from section 261 right up to section 273. And again, I'm also directing you to read and study provision on documents, how documents are served on the company, and how the company serves a document. So that is section 290 to section 293. Directing you to read and study all those provisions. And finally, I am directing you to read and study provisions on the Office of Registrar of Companies, right? That is section 351 up to section 3. Yeah, up to section 387. Yeah, so I want you to read and study section 351 right up to section 387. All right, so that is the task that you have. So what it means is that when we finish discussing the majority rule and protection of minorities, or the so-called rule in FOSS and Harbottle and the exceptions there too, in terms of our substantive discussion, we will be left with invitation to the public, right, in relation to public companies. So over the weekend, we come online and then we do that. And then again, there's a topic which you ought to have discussed with the Dr. Adaka, but it's still not discussed. So we will also discuss that. That is the arrangement or amalgamation. That is like the corporate transformations, right? Corporate mergers, acquisitions, and things like that. So we will look at them. I'm talking about section 238 up to section 260. Yeah, and then we are done with everything company law, and you are ready to write your exams. Now, before we continue with tonight's discussion, let me remind you that I have decided to vary the style of your examination so that the task that we have given you to read and study various provisions, and of course, to take all that we have been doing since the beginning of the semester, myself, Dr. Dakwa, and our tutorial assistant, Mr. Ezekiel Osei, you take all those things serious. On characteristics of me for quite some time now, I mean, for almost the past 8-9 years, I have stopped what we call compulsory question. Unfortunately, observing how students are, I have fallen to the temptation to go back to compulsory question. So you're going to have one compulsory question in session A, and then in session B and session C, answer one question each, right? So session A is compulsory, and then session B, you have a number of questions, answer one. Session C, a number of questions, answer one. So that is what you are going to get in the examination. And let me remind you, because we are friends, so that we have a clear picture of how things will be. Somebody will say rhapsody of realities. The compulsory question will, as far as possible, endeavor to encapsulate or mirror, or if you like, reflect all that we have done in the semester. And what that means is that there is no question of, for me, it is this topic that I like. So I'm going to learn more about shares, and I don't care about corporate insolvency and restructuring, or I am interested in protection of minorities and majority rules. So I don't care about duties of directors. I don't care about debentures, or I don't care much about arrangement and amalgamation. No, we have taken that luxury from you. So you have to take everything serious. And again, there's nothing like multiple choice, okay? So that is what you are going to get in the examination. So that said, we proceed with our discussion of majority rule and protection of minorities. And of course, let me also be fair. If we take Mr. Justice Kusimin Kaprimo and Kwamina Mensah, they've also done a useful work. And if you look at the chapter 12 of that, they discuss the same thing as Mr. Ferdinand Adaji has discussed in 23, that is remedies for corporate wrongs, as it were. Good. So as I said, let's get the context. So the context is that we know that following incorporation of a company, the cornerstone principle or the elementary principle of company law is the principle of a separate legal personality enunciated in Solomon and Saruman, which is well celebrated over centuries in the common law world, and in fact, so to speak, the whole world. When you look at the case of Barcelona trashing case, and you notice that the principle in Solomon and Saruman has even made its way into public international law as well. Now, what that means is that where the company has suffered wrong, the company can sue whoever the wrongdoer is, whether it relates to breach of contract, whether it relates to tort, or some other things, including even like crime. The company can make a complaint, as it were, for criminal prosecution to be mounted against whoever perpetrated the wrongdoing against the company, as it were. Now, related to that is also the idea that where the company is the perpetrator, right, of the wrongdoing, maybe the company breached contractual obligation, or the company became a tortfeasor, committed a tort, and all that, the company can sue, right? No, sorry, can be sued by the other innocent party or the victim of the company's tort, as it were. That is fine. So if life were that simple, like how I've explained, then there'll be no room for us to even worry about all that we're going to be discussing. Nevertheless, the reality or the plain truth is that going back to the wisdom and the common dictum, which, as far as I'm concerned, have become a bit like a cliche. That is the wisdom, the dictum of Lord Cranworth in Aberdeen Railway against Blackheath Brothers, that the company is artificial legal person. It doesn't have leg, it doesn't have mind, it doesn't have hands, isn't it? The company functions through flesh and blood. And who are the flesh and blood? That is through directors, the officers, so to speak. Now, what is happening is that the wrong which the company might have suffered, right, which might have been perpetrated against the company, could very well have been done by directors. Now, if the directors, who are supposed to be the mind, the hands and legs of the company, and for that matter, if someone wronged the company, they could put on the clothing or the vestment or the veil of the company, so to speak, and use the name of the company to mount a suit to seek redress, whatever grievances the company has suffered. Now, these directors or this director, for example, is the one very responsible for committing the wrong against the company. So as somebody said, who watches over the watchman? The directors who are supposed to say that, no, the company should sue X, Y, Z. They are the very people who have wronged the company. And so you know very well that nobody will take himself to the slaughter to be slaughtered. So the company will not be able to get an action taken in its name against the directors for the wrong that the directors might have caused. And the directors might have wronged the company in a number of ways, either breaching the duties that the law has imposed on the directors, as it were, or the directors have connived with someone and so on and so forth. Again, it may well be that a third party might have committed the wrong against the company. And this wrong, which the third party has committed against the company, may affect the profitability of the company. And if the profitability of the company is affected, it's definitely going to affect the ability of the company to pay good dividends to shareholders, meaning that shareholders are going to suffer. For that matter, where third parties have wronged the company so that it affects the financial position of the company and the company's ability to pay dividends. Shareholders may, for example, want to assert their right against the perpetrators of the wrongdoers on behalf of the company, as it were. Another reality from the corporate life or from the life of the company is that when it comes to decision making in the company, already we have noted the two major organs, right? The two centers of power. The shareholders in general meeting, be it annual general meeting or extraordinary general meeting, and then we've also seen board of directors. Now, each of these organs, when they are functioning, they function through decision making. And how are decisions arrived at? Decisions are arrived at by majority. If what's happen, we will say that, okay, let's have a poll. And if you have a poll or whatever means that we are using to determine the decision, we are going to take the position of the majority. That is how it is. Now, those who may lose out when a poll is held or when we put matters to vote, those who may lose out, that is the minority, or what they call it, dissentient members. They may, for example, feel strongly that what the majority have done is actually wrong. But ultimately, it is not how loud you're able to say that we are wrong, which matters. It's really about how many votes are you able to cast? Because ultimately is the votes which is going to determine which position the company is is taking. So in politics, as we say that the minorities will have their say and the majority will have their way, isn't it? The minority, yes, you can have your say, but ultimately it is the preference of the majority represented by their votes, which is going to matter as it were. Now, that being the case, the minority may, for example, want to take a legal action on behalf of the company against the majority, because the majority might have arrived at a decision or a resolution which the minorities feel that it is really detrimental to the well-being of the company. But the majority are those who are in charge. So the minority may not want to just sit back for the majority to hijack the company and do things which are quite detrimental to the interests of the company. So they may want to what? They may want to sue. But then, if they also decide to do that, before you can sue in the name of the company, you need to get the company to give its blessing. And then if you are to put it to vote, it is a majority who are going to win. And they will say that, well, it's not necessary to go to court because the majority are those who are doing things that are inimical to the interests of the company. So that therein lies the conundrum, the complexity which we are talking about. Another point worth taking is that since, as we noted, the company is an official legal person, where the company has committed a wrong against a third party, the third party may want to sue the actual human being who committed the wrong rather than the abstract entity called the company. Because the company cannot physically be located, isn't it? It's an abstract thing. Now, in the wake of all these realities and complexities which have been highlighted, we come to discuss the various ways in which remedies or reliefs may be provided for wrongs against the company or wrongs involving the company. And that is why I think that for good reason, Mr. Daje decided to abandon the usual style, which is encountered in various company law textbooks that, for example, like I mentioned, majority rule and protection of minority, or some others will say that the rule in FOSS and Harbottle needs exception. Of course, if you take Professor Bonzi Simpson, he will also prefer to call it remedies for improprieties, as it were. Be that as it may, what is really essential is that we seek, of course, within the framework of Part R of Companies Act 2019 992, I'm referring to from section 218 following, we seek to explore the following, that if the company, for example, is wrong, who can take legal action on behalf of the company, having regard to all that we have talked about, the rare problems, and then what specific corporate wrongs can be subject matter of legal action, either by the company or on behalf of the company. And then what legal reliefs or remedies may be given when actions are taken in relation to the corporate wrong that might have been caused to the company. Now, the starting point in all this is a very old and interesting case, which all of you might have heard about, the case known as FOSS and Harbottle. FOSS and Harbottle, a very interesting case. And FOSS and Harbottle, what is it? What is it? Essentially, FOSS and Harbottle, a case decided in 1843. When you look at the 1843, laid down two important principles concerning how an action may be instituted for corporate wrongs, that is wrongs which the company has suffered. But you notice that if you look at that rule, it has witnessed so many exceptions. And that is why I initially said that some people even call it the rule in FOSS and Harbottle and the exceptions there too. And if you are to scrutinize the exceptions, you notice that exceptions are even more than the principle. And some will say that the rare principle enunciated in FOSS and Harbottle have substantially been whittled away, so much so that we could even ignore it if that were ever possible. So we notice that the two principles enunciated in FOSS and Harbottle just refer the proper plaintiff rule and then the majority rule. We come and explain what we mean by the proper plaintiff rule and then what we call like the majority rule enunciated by the court in the FOSS and Harbottle. Just once. Good. So I said that the first rule in FOSS and Harbottle is what we call like the proper plaintiff rule. And what this simply means is that where a wrong is committed against a company, the only person having capacity to sue is the company itself. And that's why we say proper plaintiff. Who is a plaintiff? A plaintiff is the one who initiates a cause of action, who initiates a case. So when we say proper plaintiff, that is who can actually sue where there's a corporate wrong, where the company has suffered the wrong. And FOSS and Harbottle said that it is the company which is at the receiving end of the wrong that can actually take an action to seek a redress. And that is why we call it the proper plaintiff rule. And then the second aspect is what we call the so-called internal management rule, or what we call it the majority rule, simply meaning that where things are done irregularly, if you don't follow laid down procedures and so on. And if those irregularities can be cured or overcome by majority, when they resolve to absorb all wrongdoings, then you cannot complain about it. Even if you went to court and the court, for example, made orders, those orders could, for example, be rendered odious. That is useless, so to speak, in the sense that what the court has declared, for example, as irregular, the majority will vote and say that, well, we have actually regularized that which was irregularly done. If it lies within the competence of the majority to vote, that so be it. So that is the thrust of what you call the rule in FOSS and Harbottle. But it will be interesting for us to briefly look at what happened in that case. So in FOSS and Harbottle, Richard Foss and Edward Starkey-Tartan were two minority shareholders in a company known as Victoria Park Company. The company had been set up in September 1835 to buy a land near Manchester, which became the Victoria Park, Manchester. The claimant, that is a plaintiff, alleged that a number of improper and fraudulent transactions have been entered into, and the property of the company have been misapplied and wasted, and various mortgages were given improperly over the company's property by the directors. And the claim also was that somebody is asking if I can type the case of FOSS and Harbottle. Okay. FOSS versus Harbottle. Yeah, so the other part of the claim was that the directors have made a secret profit, right? Remember secret profit from discussion of the issue of directors. That the directors had made like the secret profit and had accordingly breached their fiduciary duties to the company. So the claimants asked that the directors and officers liable for the wrongs be held be held accountable to the company for the various wrongs, and that a receiver be appointed. Now, the defendants who were sued were actually 5 directors of the company. So 5 directors of the company were sued for those which have been mentioned. And eventually, the court dismissed the claim brought by the plaintiffs, and among other things held that when the company is wronged by its directors, it is only the company that has capacity, local standard, or standing to sue. And for that matter, 2 rules are applicable in an action for wrong committed against the company. Firstly, the proper plaintiff rule, which we've explained, that a wrong done to the company may be asserted by the company alone. It is only the company that can sue in respect of a wrong done against it. And secondly, the majority principle rule, or the internal management rule, that if the alleged wrong can be confirmed or ratified by a simple majority of members in a general meeting, then the court will not interfere. But what the court will not do is to render itself, if you like, a toothless bulldog, which can bite but cannot bite, or for the court to appear to be impotent in the sense that it's, for example, make orders which cannot be executed, which cannot be enforced. The reason being that the company will be able to pass resolution to do opposite of what, for example, the court might have actually concluded. And so that is essentially the principles which the court said are relevant when a wrong has been done against the company and there's a need for an action to be taken. Yeah, so go and read the FOSS and Harbottle, but that essentially that is the thrust of the principles which the court said should guide whenever a wrong has been done against the company. And the majority rule principle which we have discussed is actually not strange. It is a logical inference from the elementary principle, that is the legal personality principle we have already seen in Solomon and what? In Solomon. because we've seen that the company has a separate legal personality. If it has a separate legal personality, what it means is that it can sue and be sued and so on. Good. So how does the company function? The company functions through human beings. Human beings, how do they do things? We have to take the majority position, isn't it? So if the majority can resolve to correct that which appears to be defective, so be it. But it's important to note that this FOSS and Harbottle, which has actually influenced company law in the common law world for a long period of time, has been justified by a plethora of authorities. So many cases have actually sort of rationalized or justify why the principles in FOSS and Harbottle are good law. For example, if you cite the case of Prudential Assurance against NEWMAN Industries, let me put it there. Prudential Assurance against NEWMAN Industries Limited, number 2. So 1982. Yeah, if you take that case, for example, that Prudential Assurance against NEWMAN Industries Limited, number 2, a shareholder instituted an action to recover loss resulting from the diminutive value, that is the reduced value of shares of the company due to damage suffered by the company. How did the damage come about? That as a result of action of the defendant, the matter eventually made it to the Court of Appeal, and the Court of Appeal all holding that a shareholder is not proper plaintiff to sue for damages caused to the company. Explain or rationalize the wisdom underpinning the proper plaintiff principle in the following words. The elementary principle that A cannot, as a general rule, bring an action against B to recover damages or secure other release on behalf of C for injury done by B to C. C is the proper plaintiff because C is the part injured, and therefore the person in whom the cause of action is what? Is vested. This is sometimes referred to as the rule in FOSS and Harbottle when applied to corporation, but it has a wider scope and is fundamental to any rational system of jurisprudence. And again, the majority rule has also been, of course, these cases we are talking about are not new to our own jurisdiction. In the first semester, you came across the case of Appenting against the Bank of West Africa Limited, isn't it? Appenting against the Bank of West Africa Limited, 1961, one Ghana law report, page 196, a high court decision though, but it's sort of followed the principle in FOSS and Harbottle. And also the case of Bank of West Africa Limited against Appenting, 1972, one Ghana law report. That is the Court of Appeal decision. Now, quite apart from the justification which these authorities are giving to the proper plaintiff leg of the rule in FOSS and Harbottle, the majority principle in FOSS and Harbottle has also been rationalized in a number of cases, including the case of a Backshaw against Eastern Union Railway Company. Backshaw. In fact, you shouldn't be worried by some of these cases unless you are invited really to do an essay question regarding them. Otherwise, if it is a problem-based question, as I always tell you, in a problem-based question, you're supposed to behave like a lawyer who is solving like a problem. Apply the law as in force. But now what we are trying to do, we are trying to build the historical development of how we got to the principles which have been embodied, right? Which have been embodied as the illegality and protection of what? Protection against oppressive action and all that. We're just trying to explore how we got there. And that is why I'm making some of these excursus. But as I keep saying, if you're doing like a problem-based question, you need to go straight forward to the point, the law as it is now, and not how the law became what it is. It is only in the essay question where you need to explore the path or the trajectory along which the law has actually evolved. Having said that, let's go back to Backshaw against Eastern Union Railway, when the court sought to just explain, right? Explain the majority rule, and how did the court explain that? Quote, if the act, though it be the act of the directors only, be one which a general meeting of the company could sanction, a bill by some of the shareholders on behalf of themselves and others to impeach that cannot be sustained, because a general meeting of the company might immediately confirm and give validity to the acts of which the bill complains, unquote. So simply put, just trying to say that if there's something have been done by directors or some officers wrongly, and that which has been done can actually be approved by the shareholders using the necessary majority and all that, then the court will not second guess that. If you remember from discussion of directors that the members in general meeting, for example, they have the power to ratify, right? To ratify, that is, to give approval to that which even directors did without authority, or they didn't follow certain procedure. They can pass resolution to ratify that. And that is also an expression of the majority rule that we are talking about. Then the bigger question is this. Yes, we have understood the proper plaintiff rule. We've understood the majority rule, all emanating from the FOSS and Harbottle. But as a matter of legal policy, right? As a matter of legal policy, can we have any justification? Can we actually see some wisdom? Is there any wisdom really in these principles? Well, a number of ideas have been bandied about by text writers. So one of the justification given for the principles in FOSS and Harbottle is that it avoids multiplicity of suits. So what we call the floodgate argument, right? The floodgate argument. That is to say, just imagine that you have a company made up of so many members or shareholders. So something has gone wrong. Shareholder A will bring an action. The same thing, shareholder D also sees it. He too can bring an action. The same thing, shareholder C can also bring an action. Something else, shareholder E and all that. So you end up having the company dragged into so many litigation, and that is not really for the good of the company. So to guard against multiple suits by many stakeholders, the FOSS and Harbottle maintains that the proper plaintiff or the proper plaintiff or the rightful plaintiff where there's a wrong against the company should be the company and not the shareholders. And that was why in the well-known case of McDougall against Gardner, McDougall against Gardner, McDougall against Gardner, an 1875 decision. when Anne was not born. Lord Justice Mellish, and I'm sure you remember Lord Justice Mellish when he was talking, there's another case, he made a very beautiful dictum talking about the public policy. It's like an unruly horse, isn't it? In the case of okay. So in McDowell against Gardner, Lord Justice Mellish made the following statement, quote, looking to the nature of companies, looking at the way in which the articles are formed, and that they are not all lawyers who attend these meetings, nothing can be more likely than that there should be something more or less irregular than at them. Some directors may have been irregularly appointed, some directors as irregularly turned out, or something or others may have been done. And this is what is important to me. Or something or other may have been done, which ought not to have been done, according to the proper construction of the articles, that is the constitution of the company. Now, if that gives a right to every member of the company to file a bill, to have the question decided, then if there happens to be one cantankerous member or one member who loves litigation, everything of this kind will be litigated. Whereas, if the bill must be filed in the name of the company, then unless there is a majority who really wish for litigation, the litigation will not go on. Therefore, holding that such suits must be brought in the name of the company, that certainly greatly tend to stop litigation. So just emphasizing McDowell against the Gardner, trying to say that, yes, the proper plaintiff rule also serves as a gatekeeping rule. It guards against unnecessary and multiple suits. Okay, so that is fine. And quite apart from that, another justification is that, I made that point already, that where majority of the company can regularize an irregular act or decision, then the court will not pronounce on it, right? The court will not pronounce on something which is an irregular, that can subsequently be regularized by the company. And then the court will turn itself, as it were, into a laughing stock, as we saw from the case of the Berkshire against Eastern Union Railway company. So let's take note of that. Yeah, so you see some wisdom in having this particular principle. Of course, another justification is that the courts are generally reluctant to make or interfere with business decision or business policy, right? Because the power to make business decision, make policy, is conferred on directors, right? And of course, in appropriate cases, members in general meeting, as we saw. You remember major transactions, and it's something that you have to remember it on your fingertips as well. I'm not saying you should memorize it, but you should know it. Remember major transaction under Act 992, where it is a requirement that you get approval from the members in general meeting. So when, for example, it comes to those matters, the courts are not willing, or the courts do not rush to try and interfere with either the power of directors or power of members in general meeting. And that was why in Howard Smith Limited against Ampol Petroleum Limited, and you've met Howard Smith against Ampol Petroleum when we're discussing duties of directors. Howard Smith against Ampol Petroleum Limited. So in Howard Smith against Ample Petroleum Limited, a 1974 decision. Lord Wilberforce made an observation, which I quote: "It will be wrong for the court to substitute its opinion for that of the management, or indeed to question the correctness of the management's decisions. On such a question, if bona fide arrive at, there is no appeal on merits from management decision because of law, nor will cause of law assume to act as a kind of supervisory board over decisions within powers of management honestly arrive at," unquote. So Lord Wilberforce was making the point in Howard Smith against Sample that insofar as directors have acted in honesty, that is in bona fides. Yesterday, I think yesterday or the Tuesday, we had a class. I explained what the law means when you say bona fides, when you say you're acting in good faith, that you're acting like honestly, in all sincerity. So long as the directors have exercised their powers and acted in honestly and all that, and arrive at a business decision, the court will not question that. I mean, that is a point which is being made. Another explanation or justification for the principle in the FOSS and Harbottle has to do with, as we've mentioned, the cornerstone principle of company, that the separate legal personality. We know that the company is separate and distinct. It can sue and be sued and all that. If it can sue and be sued, then definitely it is a company which is the proper word, plaintiff. And we have seen that. You remember Moko against Kuma, the well-quoted dictum of Sophia Kufu GS, as she then was, right? That the company can sue and be sued and all that. So these are some of the arguments which are made to support the principle in FOSS and Harbottle. But as we noted at the beginning, that the principle in FOSS and Harbottle is not a principle which is cast in stone. It's not sacrosanct, right? Or is not indefeasible. A number of exceptions or derogations have been developed to that principle or rule in FOSS and Harbottle. So we will explore some of these exceptions which were developed at common law, right? To enable us go around the rule in FOSS and Harbottle. Now, when we are done with that, we will now come to look at the provisions of our act and see how our law has even developed the law further and better than what the common law was. And as I told you, all these are academic excursus. Because we are becoming lawyers, we need to go into history to understand where the law is coming from. Otherwise, all these things I'm telling you are not really important. We can just read the act and then we have the position. But we just want to appreciate where the law is. That is why we are exploring some of these matters, as it were. Okay, good. So a number of exceptions have been developed to the two-fold principle in FOSS and Harbottle, the proper plaintiff principle and then the majority rule principle. And what are these exceptions? These exceptions relate to protection of personal rights of members. That is to say that if what is at stake, right, has to do with the personal right of members, then the rule in FOSS and Harbottle will not serve as a stumbling block and say that the company is the proper plaintiff, because the wrong which has been experienced or which might have been occasioned may be against the personal right of members, as it were. And another exception relates to where a remedy is being provided against illegal or traverse act if something has been done which is contrary to the law or which is in excess of powers conferred by the constitution of the company. The reinforced and Harbottle may be sidestepped. Thirdly, there's also exception relating to fraud, right? Where it is necessary to avoid fraud or minority. That is where the majority, majority who are in control of the company have actually hijacked the company and they're using the company as a vehicle to perpetrate fraud against interests of minority. Then there'll be an exception to the rule in FOSS and Harbottle. And fourthly, there may be an exception in ensuring that the requirement of a special majority is not circumvented. There is, you see, FOSS and Harbottle talks about majority rule, right? But majority rule is not coterminous with special majority. If you say special majority, for example, when it comes to the passage of, let's say, special resolution, right? It requires majority, but not any kind of majority at all. It required what do you call like the 3/4 or 75% majority. So that is a special majority. And in situations where special majority like that is needed, that would be a legitimate ground to circumvent the, let's say that the majority rule in FOSS and Harbottle. Because the majority rule in FOSS and Harbottle is majority simpliciter and not special majority. So these are some of the ways in which at common law, the rule in FOSS and Harbottle may be circumvented or may be sidestepped, as it were. And these exceptions were developed in cases like Edwards and Halliwell. Edwards and Halliwell. Edwards and Halliwell. The current special prosecutor, right, who is also my mate and friend, Mr. Kisi Ajaben, did a very nice article some years ago when we were, I think, celebrating Ghana at 50 or something like that. So there was a collection of essays by University of Ghana. If I'm able to locate my copy, I will scan it and put it on your platform so that you can read that. But if you go to the library, there should be a copy of that book in the cupboard, but we check and see what it is. Okay, so in Edwards and Halliwell, for example, if you look at the facts of that case, in the constitution of the company, right, Rule 19 of the constitution of the defendants trade union provided the following quote: the regular contribution of employed members shall be as per tables, and no alteration to same shall be made until a ballot vote of members has been taken and a 2/3 majority obtained. So here you see that the Constitution has actually specified a certain type of majority, a special majority, 2/3 majority, isn't it? Which is different from a simple majority or just majority simplicity, as it were. So eventually, when the plaintiffs in this case were 2 members of the union, they brought a claim against 2 members of the executive committee of the union, and the union itself seeking a declaration that alteration adopted at delegate meeting was invalid. And what was that alteration? At the delegate meeting of the union, they did not take any ballot, and they passed a resolution increasing the amount of contribution of employed members. Meanwhile, the constitution of the company said that if you wanted to make an alteration, you needed a certain majority, what majority was needed? You needed to test majority. Now, eventually, when this was challenged and it went through the courts and eventually go to the English Court of Appeal, Lord Justice Jenkins, speaking for the English Court of Appeal, had the following to say, which embodies the exceptions that will be alluding to quote. The rule in FOSS and Harbottle, as I understand it, come to no more than this. First, the proper plaintiff in an action in respect of a wrong alleged to be done to a company or association or person is prima facie the company or the association or person itself. Secondly, where the alleged wrong is a transaction which might be made binding of the company or association and all its members by a simple majority of the members, no individual member of the company is allowed to maintain an action in respect of that matter for the simple reason that if a mere majority of the member of the company or association is in favor of what has been done, then cadet quasito, no wrong has been done to the company or association, and there's nothing in respect of which anyone can sue. If, on the other hand, a simple majority of members of the company is against what has been done, then there's no reason why the company itself should not sue. In my judgment, it is implicit in the rule that the matter will lie on as constituting the cause of action should be a cause of action properly belonging to the general body of operators or members of the company or association, as opposed to a cause of action which some individual members can assert in its own right. So that is why we said that where what is being complained about relates to personal right of the member, then the rule in FOSS and Harbottle does not apply. And we get this from Lord Justice Jenkins' dictum in Edwards and Halliwell. Then he continued, quote, the cases falling within the general ambit of the rule are subject to certain exception. It has been noted in the course of argument that in cases where the act complained of is wholly or traverse the company or association, the rule has no application because there is no question of the transaction being confirmed by any majority. So if the matter is ultra-virus, what it means is that it's beyond what is authorized by the object clause of the constitution of the company and all that. And then the court is saying that in that case, there's nothing like a majority rule. It has been further pointed out that where what has been done amounts what is generally called, in this case, a fraud on the minority, and the wrongdoers are themselves in control of the company, the rule is relaxed in favor of the aggrieved minority who are allowed to bring what is known as a minority shareholders action on behalf of themselves and all others. The reason for this is that if they were denied that right, their grievance will never reach the court because the wrongdoers themselves, being in control, will not allow the company to sue. Those exceptions are not directly important in this case, but they show, especially the last one, that the rule is not an inflexible rule and it will be relaxed where necessary in the interest of justice. So Lord Justice Jenkins has said it all, that the rule in FOSS and Harbottle is not an inflexible rule and it will be relaxed where necessary in the interest of what? Justice. So let's keep that in mind. So maybe if in examination we said that the rule in FOSS and Harbottle is not an inflexible rule and it may be relaxed in the interest of justice and all that, discuss, then to what extent does the realization permitted by this rule has been improved by provisions of Companies Act 2019 Act 992, something like that. Yeah, so we've seen like the exceptions are the common law, right? Now let's come back to our own law. That is Act 992 to see how these exceptions, which we have discussed, have been improved, right? So let's we start from the right of members to sue, because that is one of the exceptions recognized at the common law, and as we also saw in the Edwards and Halliwell as it were. Now we know that if we look at our Companies Act in a number of ways, it allows member or members to sue either in their name or even sometimes in representative or capacity. And from our discussion of directors, I think we actually encountered that. So maybe let's look at the situation where a member is suing for a wrong affecting the member, right? Where a member is bringing a legal action for corporate wrong against the member, which affects the personal right of that member. Let's, for example, look at our section 29. Let's go to section 29. Our class reader, who is reading for us? Who is reading for us? Are you sleeping? Okay. Manel.
Hello, Doc.
Yes, let's look at 29, for example.
Okay. Section 29. Subject to this act, the Constitution has the effect of a contract under seal, A, between the company and each member or officer, and B, between the members or officers themselves, by which they agree to observe and perform the functions contained in the Constitution as amended from time to time, insofar as they relate to the company, the members, or the officers.
Are you then let's look at the subsection 3, for example.
Subsection 3. In an action by a member or an officer to enforce an obligation owed under the Constitution to that member or officer and any other member or officer, that member or officer shall, if any other member or officer is affected by the alleged breach of the obligation, sue in a representative capacity on behalf of that member or officer and all other members or officers who may be affected other than those who are defendants in the provisions of section 205 shall apply.
Okay, good. So from section 29, which actually discusses the legal effect of company constitution, that it is a contract under seal and so on and so forth. It creates rights, right? It creates rights and obligation. And where the company's constitution, for example, is breached, and it affects a member, of course, because the contract between the company and the member, and then the members, members, and then the officers, and so on. Any breach of it confers even a personal right on the member, and that person can sue to enforce it. So here, you see that our law recognizes that despite what the old common law position was, of course, and consistent with the exception being developed there, like the Edwards and Halliwell, a member can maintain an action to vindicate any personal grievance emanating from breach of the Constitution. But except that, in order to guard against multiplicity of suit, right, our lawmaker our lawmakers in their wisdom have also retained some of the policy rationale of FOSS and Harbottle by saying that if you want to bring an action to enforce breach of the registered constitution, you must do so in representative capacity. Doing so in representative capacity will actually avoid multiplicity of suit. And if you look at the Professor Gawa's commentary on the repeal at 1.7 now, which is in paramaterial with our current Act 992 in a number of ways, you notice that because the constitution is a contract between all the members and the company officers and so on and so forth, a breach of it may not be seen only by one. And so many other members may also become cognizant of that. And if each of them had to bring an action independently of the other, you can imagine a situation where in respect of one infraction of the provision of the company will be inundated with multiplicity of suit. So to guard against that, the lawmaker said that if you are suing representative capacity, and that is to say that you are suing not only for yourself, you're also suing for and on behalf of other members of the company who are similarly affected or who are similarly situated as you have. So please go back to section 205 and read all the provisions of representative action, right? Last semester, we alluded to it and we are alluding to it again. So 205 on representative action, right? We are not reading that, but I'm just asking that you should read it on your own. Now, there are so many other examples where a member may bring an action in respect of his personal right that has been violated. Let's, for example, look at the situation where unlawful dividend is being paid by the company. Let's, for example, look at section 72, right? Let's look at section 72. Section 72. There are so many things. We are just picking and choosing. We are just citing instances where Act 992 recognizes that a member will be able to bring an action against the company. And of course, that is contrary to the rule in FOSS and Harbottle. But as I told you, in a common law, where the personal right is affected, the common law recognizes that FOSS and Harbottle could be what? Could be relaxed or could be sidestepped. And it's exactly thing that we have in our own law. So I said section what, 76? Yes.
70. Did you say 72 or 76?
Well, okay, let's look at 72 first. Legality of the dividend.
Section 72(1).
Let's go to the 3 because if discuss this under shares already, isn't it? So let's look at what we need.
Yes, please. Section 72(3). A shareholder, an officer or a creditor of the company, or the registrar may apply to the court for an injunction restraining a company from paying a dividend or from making a return or distribution in contravention of this section, or for an order for restoration in accordance with subsection 2.
Good. So here you see that where dividends have been paid out in a manner contrary to that contemplated by the law, a shareholder who is a member or even a creditor can actually go to court and seek an injunction to redress that. So that is another example. And here too, you notice that it will also have to follow the representative action. So section 205 is important because section 205, which talks about representative action, is triggered or implicated whenever a member or a person is authorized by the law to bring an action, right, concerning something against his personal right, and he's not the only person who is affected by that, and other class of people have also been affected, then the law does not want an avalanche of litigation to be instituted against the company. So the law says that, yes, you can bring an action, but the action that you are bringing it for on behalf of yourself and on behalf of all those who are similarly affected. And that is why it will be prudent for you to build some kind of support so that in terms of financing the action and all that, you share the burden. Because if you don't share the burden with them, should there be victory, the victory will not be enjoyed by you alone. So that's the thing about representative action. Another example, we can go to the 76, for example. Let's look at the 76. Another example where you can bring the
Section 76, subsection 1. Subject to subsection 1.
Yeah.
Subject to sections 72 and 75, and in the case of a private company, its registered constitution where applicable. A company may, by ordinary resolution, declare dividends in respect of a year or any other specified period, but a dividend shall not exceed the amount recommended by the directors.
Okay, so I mean, we can read the rest, but it just giving us more principles which govern proper declaration of dividends, and where they are infringed, then it entitles a member or a creditor to go to court and seek the necessary remedy. And not only that, we can have so many examples, right? When it comes to variation of a class rights and all that, if it's not properly done, if you look at section 50, any member of the class affected by the improper variation could, for example, go to court. And then when you go to court, as I said, you still have to be guided by section 205. It will have to be a representative action as it was. So let's keep that in mind. Yeah, so I think that is enough example. So you can even pick so many other examples yourself. But all that we have done is to demonstrate that the Companies Act 2019 Act 992 permits members to have recourse to courts where their rights conferred on them as members, either under the Companies Act or under the constitution of the company, for example, have been violated or have been breached, as it were. The only rider is that where they bring an action, they have to do so in representative capacity in conformity to section 205 as it were. Now let's look at another aspect of personal action, that is action by a member for wrong affecting the company. The first one we saw was about an action by a member for a wrong affecting the member, either affecting the member or affecting the class to which he belongs. That's what we've looked at. Now let's look at the related scenario where the law permits a member to bring an action for redress in respect of a wrong affecting the company, not affecting the member directly, to speak, as it were. Now we know, if you remember division of power between members and also directors, remember what we call like the section 144, right? But I would like us to look at section 144, subsection 5, just to drive home the point. Where, for example, we have like division of competence, right, between members in the committee and directors, and those, let's say that who have been given the powers, they fail to act. How can, yes, Mr. Frank Dakwa, you can mute yourself and talk. Frank?
Say.
Yes.
I want to ask a question, please. Looking at the rule in the FOSS and Harbottle, the proper plaintiff rule, if I understood you correctly, then we are looking at where a member or the fact that the proper plaintiff to sue on behalf of the company is the company itself and not a member. But then the provisions that we were looking at earlier were sort of pointing to where the member can sue the company itself and not for and on behalf of the company. So I'm getting a bit confused with that.
Okay, good. So the examples that we look at, right? That where, for example, dividends have not properly been declared, or where, let's really look at the constitution, where there have been breaches of the constitution of the company, that a member can take an action to enforce that. Now, it is not necessarily the company which might have done something wrong, right? But maybe like the directors or some officers in charge who have not carried out provisions of the constitution. And that is still a breach. And because the constitution is like a contract under seal between the members, the company members and officers in the sea and all that. Ordinarily speaking, if we are going strictly by FOSS and Harbottle, the argument would have been that if provisions of the company's constitution in those days, articles of association, memorandum of association, have, for example, not been complied with, it is a company who is injured, and it's the company that must take action to get a redress. So the orthodox position will have been like that. But as we have noted that, I mean, that rule has not stood still. And even at common law, we've seen how, in terms of like where the particular wrong relates to personal right of a member, he'll be able to bring that, and he doesn't need to wait for the company to bring that. And we are saying that that has even been developed further in our law. So our Companies Act or Modern Companies Act actually go further than the exceptions developed to the rule in FOSS and Harbottle at common law. And that is why we have been citing that if you take even like, let's say, section 29, it's going far beyond that, because section 29 does not say that it is only where, a breach of the registered constitution affects your personal right before you can go to court. No, all that it says is that where there's a breach, isn't it? Where there's a breach of the constitution, because it is a contract under seal and all that, any member can, for example, take an action. And every member has similar right, because it's a contract between all of them. And that is why we are told that you have to bring the action in what representative capacity. It doesn't necessarily mean that you have really any direct personal interest. But if we're going by the Edward and Halliwell type of exception to FOSS and Harbottle, the argument would have been that you must be able to, if you like, show direct personal, if you like, right or interest as having been violated. So all that we're trying to do is that, and that is why, for me, if not even for the fact that as students who are becoming lawyers, we need to have like a deeper understanding of the law, the evolutionary trajectory along which we receive the law and all that. I would have even argued that all the things I said earlier on are not important. All that we just focus on is that if you look at the Act 992, where we have corporate wrongs, who can sue? What can the person get? When can the person sue and all that? We could have just done that. But as I said, if we also did that, we would just be too simplistic, in the sense that we need to appreciate where the law is coming from, so that we have like a deeper appreciation of where we are. All right. Good. Yeah. I don't know, Mr. Date. Frank Date. Okay, reader, let's look at 144 subsection 5. We are trying to look at
144.
subsection 5.
144 subsection 5. Subject to section 145, the members in general meeting may act in a matter if the members of the board of directors are disqualified or are unable to act by reason of a deadlock on the board or otherwise.
Okay.
B, institute legal proceedings in the name of and on behalf of the company if the board of directors refuse or neglect to do so. C, ratify or confirm an action taken by
I
the
think
board
we
of
can even just stop at the B. Institute legal proceedings in the name of and on behalf of the company if the board of directors refuse or neglect to do so. As I said, on day-to-day basis, is the board of directors who will, for example, be fighting the battles which are meant to be fought by the company. And they'll be doing so in the name of the company. But we've seen how sometimes the very wrong for which the company knew to sue might have been orchestrated by the directors themselves. And who will actually give a gun loaded with bullets to another person to direct it at him. So the directors may actually be reluctant in doing that. And that is why the lawmakers in their wisdom contemplated and provided that where that is the case, then the members in general meeting can bypass the directors and call the shot in terms of whether an action should be taken on behalf of the company or not. Otherwise, ordinarily speaking, the power to sue on behalf of the company is actually vested in the directors, right? It's vested in the directors of the companies and not the members in general meeting as it were. But we have seen where this may not be forthcoming due to the fact that directors themselves may be complicit in the very malfeasance or the very wrong, which needs to be redressed as it were. Okay, let's also look at an action to enforce breach of duties by directors. An action to enforce breach of duties by directors. And we've been discussing that this week. Directors have various duties, and where the duties are not observed, then various actions are contemplated by the law. So let's go back to section 200. Section 200.
Section 200. Okay. Section 200. Subsection 1. Proceedings may be instituted by the company or by a member of the company to A, enforce the liabilities referred to in section 199. B, restrain a threatened breach of a duty under sections 190 to 192. C, recover from a director of the company a property of the company. Please, should I end there or should I read subsection?
Yes, because of time, we cannot read all, but I will consider the entire provision as having been read because the entire provision is supposed to be read, so there are commentary on it, but because of time, we cannot read everything. But what we see from section 200, right, is that there's a retention of FOSS and Harbottle. At the same time, an exception to FOSS and Harbottle also contained therein. Because if we look at the 201, it says proceeding may be instituted by the company. That is the proper plaintiff, isn't it? And at the same time, you see the disjunction or by a member of the company to enforce what? liabilities referred to in section 199. If you go to section 999, right? Let's quickly look at section 999. It's talking about where a director has failed in his duty, civil liabilities that may be brought against the director, especially so where the breach of duty by director has caused the company to lose money, right? Has caused a loss to the company, or maybe the director has enriched himself at the expense of the company by way of secret profits, or the director has, for example, entered into a contract or any transaction, right, with the company in a manner which did not follow, let's say, that the conflict of interest principles. So all these are some of the instances in which proceedings may be brought either by the company or by a member. And look at it, by the company, for the company who are supposed to do that, the directors will have to call the shot. But since the directors, for example, a director might have breached the duty, and these directors are colleagues, isn't it? You scratch my back, I scratch your back. So one director has failed in his duty. The company must actually take an action against him, but they don't want to do that. And that is why we saw that in section 144 and in 5, which we saw not long ago, that the members in general meeting could, for example, call the shot. And that is another instance. Or even a member, not even, you don't even need to even go for general meeting. A member can even take an action to do all these things relating to duties of what? Of directors. So that is another thing that we should pay attention to. But I think that what we know we are seeing is that in terms of those who can bring an action to enforce liabilities either on behalf of the company and all that, you have discussed the Corporate Insolvency and Restructuring Act of 2020, right? If you look at Act 1015, especially section 283, section 97 of the Act 1015, and also if you look at the section 283, right? Look at section 283 of Act 992. Let's go to section 283, for example.
Section 283.
Yes, if you read that, the reference is made to the repealed at 180, but the reference there, the reference there to section what do you call the corporate, to the Bodies Corporate Official Liquidations Act are references to the Corporate Insolvency and the Restructuring Act. And that is why, because you notice that the Corporate Insolvency and Restructuring Act was made in 2020, and the Companies Act was made in 2019. So at the time that Act 992 was made, we didn't have Act 1015. Yeah, so, but the provisions are almost the same. But one thing we note from these provisions is that in terms of categories of persons who can initiate action in the name and on behalf of the company, right, against defaulting directors. Of course, we have like the board of directors themselves. The board of directors themselves, they can take an action in the name of the company against the defaulting director. And then secondly, we have a receiver or manager of the company. I've asked you to read all about receivers and what, and managers. And if you don't do that, you have yourself to blame during the exam. And then liquidator of the company. Who does not know liquidator of the company? Then I will explain. Okay, who will explain liquidator of company for us? Anne, are you there? Anne has disappeared. Okay. Matthew, are you there? Matthew Charles? Matthew too is not there.
Yes, please. I'm here.
Okay, Anne, who is a liquidator? Who's a liquidator? Hello? And can you hear me? Can you hear me? Hello? Hey. Anne, Abasafia, are you there? Okay, Manel, can you tell us where the liquidator is if Anne is not forthcoming?
So please, when a company is insolvent and it has to be closed down, if I should say in my own words, the liquidator is appointed to do that. That's how I can describe a liquidator.
Yeah, so simply, please, if Dr. Dakwa has discussed corporate insolvency and all restructuring with you, a liquidator is an official appointed to preside over what? The winding up or the liquidation of what? Of a body corporate, isn't it? Good. Yeah, so liquidator of a company can also bring an action on behalf of the company and then the members of the company in the registered journal and all that. Okay, so these are some. Now let's look at the action against illegal or irregular activity, right? Action against illegal or irregular activity. And of course, if you look at the FOSS and Harbottle, it suggests that where the company is doing something and it's being irregular, the majority, so long as the majority can pass a resolution to regularize that, then there's no cause for alarm for anybody to actually go to court. But that is no longer the law. And we have to go to section 218. Let's go to section 218. Section 218, an action against illegal or irregular activity. Section 218. And then let's go.
A minute. Okay. Section 218. The court on the application of a member may by injunction restrain the company A from doing an act or entering into a transaction which is illegal or beyond the power or capacity of the company, or which infringes a provision of the constitution of the company, or from acting on a resolution not properly passed in accordance with this act or the constitution of the company, and may declare that act, transaction, or resolution already done, entered into, or passed to be void.
Okay, good. So you notice that our law, section 218, is quite strict and says that where the company is doing anything illegal or irregular in terms of no following provisions of its own constitution or no following laid down procedure. Even a member, look at it, a member, not, you don't need to get the members in the general meeting to resolve, right? A member can go to court and get an injunction to restrain the company from doing that. And the injunction contemplated here may be not only one type of injunction, it can be what we call the interim injunction or interlocutory injunction. It can be mandatory injunction, right? Or prohibitory injunction. Mandatory injunction where the company has already done something which is wrong or irregular. And that is why the 2181B says that even if the transaction resolution has already been entered into, it can be declared void. Or it may be prohibitory injunction if it is yet to be carried out. They are still in the process to restrain them, as it were. But as we know that third parties, right? Third parties may be affected by these irregular transactions. Like, remember the protection for the third parties when it comes to what we call ultra-vires transaction, especially so where the company has limited its own capacity in terms of what it can do and what it cannot do. I'm referring you to like where the company has adopted like the constitution, and then by its constitution, the company has decided to restrict the nature of that can do. Of course, then the things that we know about ultra-vires will apply. But even then, as we know that the third parties will be protected, isn't it? When they are dealing with the company. So we'll have regard to section 19. If you look at the section 19, especially section 19, you look at section 19, 4 and 5, right? And of course, section 19.3 as well. And that is why section 2183 missed the point that where what you are complaining about is in excess of capacity or power of the company, it will still be subject to the protection afforded, let's say, third parties, right, under section 19, which we have alluded to already. Of course, the power to bring an action or to bring an application for injunction does not mean that, or it is without prejudice, right? It's without prejudice to the right which is conferred on a member to bring proceedings to enforce directors' breaches of duties, as it were, under section 200. But one thing which is quite telling is that the company may be overwhelmed by useless, or what you call that, the lawyers say the frivolous, right? Frivolous, unmeritorious, and incompetent applications for injunction against the company. So to guard the company against some of these unnecessary things, there's what we call a gatekeeping rule. And that gatekeeping rule is in section 2185. So let's take section 2185.
Section. Member under this section, the court may order the member to, in proceedings by a member under this section, the court may order the member to give security for the costs of the company and may direct that the application shall be heard in chambers.
Okay, good. So what section 218 is doing is sort of like a balancing act. Yes, we need to empower members who are genuinely interested in policing that the company will do the right thing. The company will not engage in illegality. The company will not engage in irregular transactions or ways of doing things. At the same time, we also need to be mindful of the fact that there are unscrupulous members. Members, especially some directors, right, may even instigate some members when maybe they have lost in the boardroom. They are having deliberations and they are passing a resolution. Maybe a director lost the vote or a particular contract, he wanted it to be awarded in certain way and so on and so forth. It wasn't done. And then he may either in his capacity as a member, of course, you can be a director and member at the same time, go to court and get an injunction to restrain the company from going ahead with that transaction. And that may unnecessarily stultify things for the company, and it may slow down the company. And here, you notice that that particular member may be acting from an ulterior motive, right? Not from like bona fides. So you go into the merit and you notice that it was just a storm in a teacup, much ado about nothing. So to protect the company from all such pestilential and frivolous litigation, the law says that where a member is bringing an application for injunction under section 218, the company can, for example, ask the court, right, to make an order directing the member to provide security. Security means that the member is bringing something in court to show that should the member, for example, lose the case and the court should award costs against that member, the member is prepared to pay or has something to guarantee payment. And again, because the action may really be frivolous and unmeritorious and could even hurt the business reputation of the company, the law requires that such application should not be in open. It should be heard in chambers. So in camera, that is just in the office, rather than in the open court, so that if application was, for example, useless and all that, the corporate image of the company will not have necessarily in. Okay, so let's keep that in mind. So let's move on to action against oppression, section 218. Sorry, section 219. The previous law, that is 179, it used the section 219, but it's now section 219. So let's look at the oppression against remedy against oppression. Let's take section 219.
Section 219, subsection 1. A member or the debenture holder of a company, or in a case falling within section 234, a member or debenture holder of a company, or in a case falling within section 234, the registrar may apply to the court for an order under this section on the ground that A, the affairs of the company are being conducted or the powers of the directors are being exercised in a manner oppressive to one or more of the members or debenture holders, or in disregard of the proper interest of those members, shareholders, officers, or debenture holders of the company.
Okay.
Or B,
so,
an act of the company.
Before that, if we look at the 219 1A, I'd like us to compare that with 2181. If you look at the 2181, it is only one particular person that can bring an action for relief under 218. That is a member, right? If you look at the 218, it's only a member, a court on application of a member, right? But if you look at the section 219, when it comes to remedy against oppression, we have 3 categories of persons that may bring an action under 219. So one, we have like the member, then we have like the debenture holder, and we have like the registrar. Reference is made to section 234. If you go to section 234, there's something you call inspection or investigation, right? In appropriate cases, the registrar of companies, so motu, that is on its own, or at the request of affected member, could make a complaint that affairs of the company are not being properly conducted. For that matter, the registrar of companies may instruct inspectors to go to the company and conduct a thorough investigation to ascertain what is going on. Now, if at the end of the investigation, a report is submitted, and then the report indicates that things are being done in a way which constitutes malfeasance and which can be treated as oppression and so on, then the registrar could, for example, bring an action, right? And bring an action on behalf of the company against those officers or those persons that have been figured in the report. That might be submitted pursuant to section 234. So that is what we should keep in mind. It's 8 and 10. I think I'm an old man and then I am tired. So then we'll continue another time again. Unless there's a question, otherwise we continue over the weekend. But for the part-time, as I said, you need to have like a class to continue funding aspects of writers. Okay. So in absence of questions, you close the class and have a very good night.
Dr. Dapa.
Yes.
Dr. Dapa, please, these days you've not been sending the recordings, and for some of us, in the beginning, the network was bad. So can you please send this recording?
If I'm to do it now, I have to stay in my office for some more 30 minutes. I'll try when I go home, okay? All right. Thank you.
Yes, please. Thank you very much.